Welcome back to another episode of the Divorce and Separation Coach podcast. This week, we're talking about cohabitating couples who've chosen not to marry, but how they untie all the financial relationships they build if and when they separate. Now, a lot of cohabitating couples don't realize that they don't necessarily have the same rights and protections as a married couple. So let's explore that a bit further. I'd love to understand exactly what rights they have and how things pan out if and when a couple who has been cohabitating decides to separate. So to talk about this topic and many other questions I've got, I've invited Oscar Smith from Expatriate Law. Oscar's an international family lawyer, and he advises on a full range of divorce and child-related issues on separation. He also helps with drafting of prenups and cohabitating agreements at the start of the couple's relationship. He represents clients from all over the world, and he's an accredited specialist in complex and high net worth divorces. And he also works on cohabitation claims following the breakdown of relationships for unmarried couples. So, Oscar, I think you have a lot of knowledge we need to tap into today. Welcome. Thank you for joining us.
Thank you very much for having me.
So, can we start by addressing that first question that I posed in the introduction? Do cohabitating couples have the same rights as a married couple if and when they separate?
So, under English law, absolutely not. It's a really common misconception that some people have, particularly people who have moved to the UK. They don't realise that there's a huge difference between people who are married or civil partnered. Those people have the same rights if their relationship breaks down. But people who are unmarried have no rights whatsoever to make claims against one another just because they were in a relationship together.
And that is no matter how long they've been together, whether they were living together or not, none of that is taken into account.
No, people assume that at some point the law would step in, but no. So you can get situations where you have couples who may have been together for 20, 30 years even. They may have had children who have perhaps they've raised and then have left home. So really serious relationships as if they were married, but they just hadn't ever signed that piece of paper. And there are no claims available to them because of their relationship if it breaks down. And so it's very different to some other countries.
Yeah.
For example, Australia certainly has these claims. After a period of time, a relationship is deemed strong enough to warrant some sort of legal protection for the financially weaker party, usually. It's an issue that lots of family lawyers have been campaigning about for many years, actually, to try and bring about a change in the law, because, you know, you can have parties left in a really vulnerable position if they've organised their finances in a certain way. Perhaps somebody's given up work, or not worked as much. Maybe they've raised the children, and then suddenly, when the relationship ends, they find themselves in a position of real difficulty, and sometimes without any recourse to anything. It's something that's really important for people to be aware of and to be educated about, I think.
Absolutely. So this whole concept of a common law marriage, it doesn't actually exist in English law.
No, a common law marriage, it doesn't exist. It's one of the most common questions we get as family lawyers, particularly from people who are from overseas who are now living there. It's one of the first questions they ask. But surely I have some rights. We've been in a really serious relationship, and sadly not. No.
Okay. So what financial claims, if any, can you make if you weren't married but you're separating?
Okay. Well, you have to remember there's a distinction between any claims that might be there are none that relate to the relationship. There are potential claims that relate to either property, or I'm going to start with talking about a situation where an unmarried couple have children.
Okay.
So what the law in England and Wales does do is it does protect children. It's in many of our statutes, you know, the first point is the welfare of a child is the most important aspect for the court. And so there are claims that parents can make on behalf of their children against the other parents, but those claims are still limited. They are not as extensive as a married couple divorcing or a civil partnership ending. But those claims, what they include, the main one is a property claim.
Okay.
So if you have the example, and typically it's this way round, I don't want to come across as sexist, but it's usually, the mum is with the young children, the parties have separated, and the dad has perhaps moved out or owns their own property, and perhaps they are the financially stronger party. The mum could, for example, in those situations, make an application to the court, or ideally just negotiate it with the father, and say, look, I can't afford a property that's meeting the children's needs. You have the money to fund that. Please, can you pay me some money in order for me to either buy a property or rent a property?
Yeah.
Now, the really important point to remember is because some people see that as quite extreme. Suddenly somebody could get a property bought for them just because they may have had a short relationship, they've had a child together, which is obviously a really significant commitment. And some people see that as unfair, that suddenly somebody should have to buy the other party a property. It doesn't quite work like that.
Okay.
It's essentially like a loan. They give them the money, and once the child is no longer a child, so usually turns 18 or finishes their secondary education, whichever comes latest, at that point the property is usually sold, and the sale proceeds will be divided to pay back the person who paid the money.
Okay.
So it's a temporary arrangement, and it's very much focused on the child.
Yeah.
There are also some other claims that you can make on behalf of your children. You can apply for lump sums. The most common ones for lump sum orders would be, for example, if one party can't afford a car and they need a car to drive around their child to the different engagements that their child has. So that's a typical one. The other example I give, a child who's an exceptional pianist, but they can't afford to buy them a piano.
Yeah.
Something like that. So those lump sums can be for almost anything, but usually you don't see a standalone claim for just a lump sum. It's usually on the side of a claim for property.
Okay.
And then there is, of course, child maintenance. Now, child maintenance is governed by an organisation called the Child Maintenance Service in England. However, there are situations where they can't deal with it. And those situations tend to be when the paying party is based overseas. So if you have one parent and the child living in England and the other parent is based abroad, the Child Maintenance Service doesn't have jurisdiction. And then the other example is when the paying party's income exceeds £156,000 gross per annum.
Okay.
And in those circumstances, you can make an application to the court for more child maintenance. Otherwise, you are governed by a statutory formula, and anyone can look that up. If they Google it, child maintenance calculator, the gov.uk, you enter your details, and it tells you how much you should be paying or should be receiving. And as part of child maintenance, you can also apply for things like school fees. If the child is attending a private school, you can ask that the other party pay or contribute towards that. And it might be that's part of a claim on behalf of your children. But that's essentially it on behalf of a child. And if the parties don't have children, that's where there's difficulty. You can only then make an application about property. But that's a slightly different situation.
And I'd love to dive into that. I just had a couple of questions on what you've just said. So just to clarify, with regards to child maintenance, it is the same treatment as a married couple. The CMS is applied and is eligible to help regulate that. It's with regards to any kind of support for in terms of housing or potential lump sums, that there's that specific route where you can request either a lump sum and or some sort of housing from the wealthier spouse to be able to maintain the right lifestyle for the child and to be able to give them the life they need. Is that correct?
That's right. And I guess the problem with these claims, as you can imagine, they're fairly limited, but they can be quite expensive to run. If you're in a court battle over these claims, it can be very expensive. So what you see is a slight difference in the case law. Lots of the case law is about very wealthy individuals who've had a child with someone out of wedlock.
Yeah.
And we're talking vast sums of money.
The footballer millionaire type of scenario.
They're buying the house in Chelsea and they're being paid £20,000 a month of child maintenance or something completely, beyond most people's budget, shall we say. And it's actually really sad because it's the people who don't have so much money. These claims can be really difficult because it's hard for them to make the application. They have a genuine need for it, but it's hard for them to be able to afford to instruct a lawyer to make the application. And it's hard to force the other parent to really engage with this. Yeah. And I think lots of people have quite strong opinions about whether or not this is fair. But particularly child maintenance, lots of people who pay child maintenance, in my experience, they feel, well, I don't mind paying for my child, but as long as not a penny is spent on my ex. Yeah. And it's really sad because what they don't appreciate is, of course, their costs are very much interlinked. Heating a house benefits the child, but also the ex. Yeah. And also putting a roof over their head, of course, does the same. So, what people, I guess, need to appreciate is that having a child means a huge amount of responsibility on parents. Yeah. They have no rights over that child, they have responsibilities. Yeah. And so this is just a way of them making sure that they are fulfilling their responsibilities in the fairest possible way and sharing the costs for that child to make sure that there's not a huge disparity between, spending time with mum and spending time with dad. They should have a broadly equal life with each of them.
Absolutely. And you mentioned earlier that the wealthier parent might be asked to buy a property. Would there be a scenario where they would rent it, or is it necessarily a purchase?
No, it can be a rental property. Okay. And there's lots of arguments about that because, of course, the wealthier party might be saying, well, I don't want to commit to having to buy a property in wherever it is. Yeah. I don't think it would be a good investment. Mm-hmm. I'm not going to make money on it. What about the tax consequences? It's very complicated. When I sell, I'm going to have to pay tax potentially. How does all of that work? And so what they sometimes say is they would prefer to put forward rental properties. Mm-hmm. And it's really it's a decision that's very fact specific. Yeah. Because of course, if somebody has a very high income but not much capital, it might be fairer for the paying party to pay more of their income in order to rent somewhere for them. Yeah. And
I guess depending also on the age of the child, if you've got a 16-year-old, you might not want to be buying a property for a couple of years, and it might be just easier to rent.
Absolutely, absolutely. And so all of those factors are built in, but also the person receiving the money, they may already have some money to put towards a property, so they just need a bit more. Yeah. And then it's about making sure the drafting of how it's put together is done to cover off all the issues such as tax. Yeah. Are they receiving their precise lump sum that they put in to the property back? Should they receive the uplift in value if it goes up, or likewise, what if it goes down in value? And it's all of these factors that make the kind of negotiation over the terms, they're really, really important. Yeah. And also the receiving party often says, well, our child turns 18, they don't suddenly leave home and have their own property somewhere to stay. And so there can be a certain amount of negotiation to try and extend the period of time. Mm-hmm. And often, courts don't tend to necessarily order the longer period of time, but when there is an agreement reached and it's relatively amicable, quite often parents decide, they need a base at least until 21, 22, finishing their degree perhaps. Yeah. And so that's really important to think about all of those different factors.
So it's quite a complex agreement to reach. There's a lot of different details to think about.
They can be, yeah.
And so what happens if, let's imagine a scenario where there are no children, but one of the two in the couple is living in the other person's property. Do they have no claims to that property whatsoever? The day they break out, they just have to leave with their suitcase and that's it? Or is there anything that can be done?
So that's, as you'll anticipate, a much more complex answer to what appears a simple question, perhaps. It really depends, the classic lawyers. So it's probably worth me just explaining a bit about the oddities of property law in the UK. In England, we have the a legal owner of a property and the beneficial owner. Now, the legal owner of the property is the person who is named. If you look on the land registry website, you can download the title deeds for different properties, and it will tell you who is the legal owner. But the oddity under English law is that the legal owner is not necessarily the same as the beneficial owner. And it's actually the beneficial owner who, in many ways, is more important, because they are the ones who own the equity within the property. So if it were to be sold, it should be paid out to the beneficial owners, not necessarily the legal owner. Now, the assumption in the law, there's a phrase, equity follows the law, which means if there's a sole legal owner, one person owns it, then it is assumed, until proven otherwise, that they are also the sole beneficial owner.
Okay.
In a joint property, obviously, if it's jointly owned, there are two legal owners and therefore two beneficial owners. And there are different ways of owning a property jointly. There are two different ways. One is called joint tenants. Now, joint tenants basically means you own the whole of the property equally together. So if it were to be sold, it's divided 50-50 between you. And the other key point about a joint tenancy is that it means if one of you were to die, the surviving party inherits it, no matter what the will says. So that's a really important point. The other way to own property, and this is what you need to do if you're going to own property in unequal shares, is own it in what's called tenants in common. And that basically means you can set out what the ownership is, what the beneficial ownership is. You will both appear as legal owners, but the beneficial title might be owned 60-40, or there might be some very convoluted and complex way of calculating it. And as you can predict, these are things that people don't necessarily think about in huge detail when buying properties. And I'm sad to say that conveyancing solicitors who have a duty towards both parties don't often push hard enough for those parties to actually go and see somebody like me, a family lawyer, deal with the fallout if it's not done properly, as to the ownership of the property, and that ideally is done at the outset. But so what you are doing, if you have a couple who are separating, they own a property, perhaps jointly or solely, you are looking for evidence as to how it is beneficially owned. So you start with the legal title, because that's always your starting point, your base assumption, and then you've got to look at, is there an express agreement? So for example, if I often get instructed to draft a document called a declaration of trust, and that is where parties are buying a property together, and this doesn't have to be in a romantic relationship. This could be siblings, it could be you and I, where you essentially write down what your beneficial interests will be. If you and I were buying a property together and you were contributing 60% of the cost and I were contributing 40%, we might say it's owned 60-40 in your favour, and that you will pay 60% towards the mortgage and I'll pay 40%, and any renovations will also be paid for in those percentages. Nice and straightforward. Sadly, lots of people don't do that, and so you don't have that express declaration as to what the interests are.
And would that be legally binding if they do have that?
Yes. So if you've got an express declaration of trust, it needs to be done correctly. So you really want it a signed contract, essentially, or what I do them is always as a deed. So you have witnesses witnessing the signature as well. That will be legally binding. No matter what follows, that will bind you. If you don't have one of those, which many people, of course, don't, you then need to really start looking at the parties' intentions. Who paid for what? Not just at the outset, but during the relationship.
Yeah.
And of course, if you're going back 10 or 20 years, this can be really difficult to document in evidence, but it's really crucial. But, who paid for the extension? Who's been paying for the mortgage? Mm-hmm. Quite often in a sole ownership scenario, you'll have, say, I don't know, one party owns the property and is literally paying the direct debit of the mortgage each month, but the other party is transferring 50% of it to them. Yeah. Now, is that 50% transfer rent? Is it being a payment towards the mortgage?
Yeah.
What was the intention of that payment?
Yeah.
And so you need to look at what evidence you can find. Are there text messages? Are there emails between them? Were there any promises? Oh, don't worry, this property is ours. I'll always look after you. Those sorts of things. You need to look at what they've been doing during the relationship.
So for the party who's contributing, say, there's one of the two who is paying the mortgage, but the other's just giving their share to their partner. They'd want to make sure that those transfers, for example, are clearly labeled as my part of the mortgage, because otherwise they're hard to tie back, right, to that contribution.
Yeah, or you'd send an email saying, I'm going to start paying X amount to you each month, and that is my contribution towards the mortgage repayment. Likewise, the other party might say, oh no, that's your rent to be able to live. But, how many people in a romantic relationship are really renting to their partner? You have to really analyse what's going on.
Yeah.
Another good indicator, particularly in parties, again, don't have to be in a romantic relationship, but let's say two siblings buy an investment property. Mm-hmm. You need to look at who's declaring the tax on the rental income for it.
Yeah.
Because of course, I dealt with a case where it was a romantic relationship, but the one party bought a property in the other party's sole name. She didn't really even know it. She just got marched down to an office and signed a document. So they could declare the rent on her income, which was taxable because she kept it all. And we ended up being able to keep the property for the wife, unmarried. We got to keep the property because, of course, the other side can't rely on something that's illegal in order to change what's been done.
Absolutely.
And the judge was very, very critical. So, looking at who receives rental income and who pays tax on it, that's a really good indicator. And also, what was the property used for is important because, if it's been used as a family home for many years and been talked about in that context, it's our home, our family home, not your property. And perhaps the person who doesn't own a share on the legal title is saying, well, of course, I paid for the mortgage up to this point, and then we had children, and then I couldn't pay for the mortgage. I took time out of my career, and I've raised the children. It's not fair that our intentions didn't change at that point, that I would have a lower interest in the property.
Yeah.
And so all of these factors are really, really important. And so, but they're all quite subjective and can be spun either way. And it's hard to produce documentary evidence to really back up your points. And so they can be quite complicated to work out, who really is telling the correct side of the story.
So it sounds like what I'm hearing you say is that the more you can document up front, the better, the more protected you will be, right? Because otherwise you do have to find kind of all that kind of scattered evidence to try and prove intent and to show how things were supposed to be, which can be quite complex.
Yeah, absolutely. I think it's crucial. And it's not just at the time, it's also, and when things change, if they have children, think about how does that change what we've already signed? Should we now review what we've already done? And open and transparent conversations between the couple are the most important thing. Yeah. But then the bit that most people don't do is then go to a lawyer and say, we've talked about this, we've agreed this, can you document it for me?
That's the problem.
And if you don't go to a lawyer, which is of course the best thing to do, still sending that email that says it and getting the other side to reply saying, yes, that's all agreed, is still really helpful. Yeah. But you've then got to keep that email. it's not a very romantic thing to be doing,
No.
I suppose. Whereas at least if you know you're going through a process of speaking to a lawyer and you're very open and transparent about it all the way through, nobody's game playing. It's just making sure that both sides have their agreement and what they deem as fair sorted out. Because unwinding all of this can be very, very expensive, very complicated. And it really, particularly where there are children, it can really damage the parenting relationship going forward because they're fighting over money.
Yeah.
And particularly where one side feels that the other side has kind of gone against what was agreed.
Yeah.
I think psychologically it has a real impact on people.
It breaks the trust, for sure.
Absolutely. I guess the other really important point to make about what claims can be made, all of this is governed by the same piece of legislation. It's called the Trust of Land and Appointment of Trustees Act from 1996. And it applies, as I said, to property, so not to a relationship breakdown. So investment or otherwise, or a family home. But the other thing that's really important to think about is applying to sell a property.
Yeah.
So often people do actually agree who owns what, but they can't agree whether or not they should sell. And of course, if one party's moved out and is saying, well, I would like my money now.
Yeah.
And the other side saying, oh, I'm nearly there, I can nearly raise the mortgage to pay you off, but that it just never happens. You might have to consider making an application to the court and asking a judge to order that the property gets sold. And of course, that's a much more straightforward application to make than the difficulty of working out who owns what.
Yeah.
But it's really important. So what I've seen is, particularly since Brexit, people who have been in unmarried couples, EU citizens, have perhaps their relationship's broken down. They may have left England and moved back to France or Germany or wherever they're from. And they feel that they can't get their money out of a property, or they haven't had their rights recognised.
Yeah.
And I've seen a lot of those cases in recent years where people have moved out and left the property with somebody living in it, and they feel that they can just kind of never get their hands on anything, and it might be that the other party could afford to pay them.
That's the thing.
But they don't know what to do or how to deal with it. But that it's an option for them to threaten to force a sale if they won't pay up. Essentially.
So those are kind of the two options in terms of liquidating that joint property. Either one of the two buys the other out, or they sell and they split the proceeds. That's kind of all they can do, really.
Yeah, and often people borrow money from family to pay them off. And what I would say is people should be pragmatic about these things.
Yeah.
There's no point forcing a sale unless you have to, I would say. Obviously there's a lot of cost that comes with selling a property and then having to rebuy as well. If you could limit that to one person and negotiate a fair split, because that other person has to then go on to buy another property, you can factor that into a negotiated settlement. And, I think that's a fairer way of doing it than forcing a sale on principle so you're in the same position. Yeah,
I agree. So we touched upon this a little bit throughout, but it'd be really helpful to kind of get a summary in terms of what people can do to protect themselves as they're entering into this kind of unmarried relationship. How can they protect themselves upstream? You mentioned cohabitation agreements, but what can they put in place?
Okay, so I think this is really important, and the most important part of it is actually having an open and transparent discussion between the couple before moving in. Whatever the situation is, are you moving into somebody else's home? What is expected of you in terms of payments, and what are those payments for? And it's, having that discussion at the outset is really important. If you're buying a property together, again, really important. And so what you should then do is have that discussion and then speak to a lawyer. And a lawyer shouldn't represent you both. You speak to your own lawyer for independent advice. And there are essentially two documents that I draft, and they almost merge into the same one at times. You have cohabitation agreements. Now, those are bigger documents because they can set out intentions as to cohabitation.
Okay.
And we're talking, we could have minute detail. Who's walking the dog when?
Oh, wow. Okay.
Who's doing what chores?
So during the relationship as well, it's not just for when it breaks down?
Yeah.
Okay.
No, this is before, this is entering into a relationship or moving in together, or they've already moved in together and just want to document something. So all of these, of course, minor points are non-binding.
Okay.
But what they are is they're setting down a marker of what they intend. And of course, if one party just doesn't stick to their side of the agreement, then the other party's more likely to end the relationship, I guess.
Yeah.
And lots of people don't put any of those details but some do. I remember doing one over a barge once, a house barge thing.
Okay.
And there were all sorts of strange upkeep of the boat that they put in. But anyway, the most important point and the bit that will be legally binding is what's called a declaration of trust, and I mentioned it earlier. Yeah. So you can have a standalone declaration of trust, as I talked about earlier in the example of us two owning a property together. But you can have that inside a cohabitation agreement that sets out all the terms. And there are lots of bits and pieces that people don't necessarily think about. What if there are changes? How does that impact percentages? You don't need to set out, it's 60-40 and it will always be, no matter what the financial contributions are. What you can do is say, the property was purchased for this amount, and this is, Y amount was paid by this party, X amount by the other party, and they may be different, and then just say the mortgage is at the moment going to cost this per month, and they haven't worked out exactly how they pay towards it, but what they will do is essentially make a spreadsheet writing down everything that they pay towards it.
Okay.
And you could say, improvements or repairs that cost above £1,000 or whatever, you pick your figure, they get added to the spreadsheet.
Yeah.
And then you have this long spreadsheet, and when it comes to selling the property, you then look at the spreadsheet and work out your percentages of what you paid. And it's a really, it's a really accurate and fair way, I guess.
It's based on actuals rather than an assumption.
Yeah. So some people like that very precise nature. Others don't like that so much, particularly when they're anticipating having children.
Yeah.
And I think that's the real change, because of course it almost always means that one party's income will go down for at least a kind of period of 9 months a year, possibly much longer.
Yeah.
And it's a break from their career, and they don't have the same career progression as a result. And it's thinking about what happens in those circumstances. And the fairest way to do it is to realise, if you're having children together, this is a really serious relationship. That's a bigger step than buying a property together.
Absolutely.
Sure. And so, why should that change what you intend beforehand? Just because you're becoming more of a joint team.
Yeah.
And your income is, personally, I feel that you should then start viewing it more as a joint income rather than sole, because there's a reason why one of you is earning and the other one isn't, because you've taken that decision in terms of childcare. You can also do things like governing joint accounts. We'll each contribute X amount per month to the joint account. The joint account will be used to pay all of these outgoings. You can have whatever you like in there.
So Oscar, just a quick question. Do people include elements around child arrangements if they were to separate? Would you say something along the lines, I would have them every other weekend and you'd have them at Christmas, or would that be something that's too soon to put in there?
So you could put that in there in a cohabitation agreement, but to be honest, you don't normally, because the needs of children, it's very hard to predict, first of all. And it might be that you're drafting the document with the children already born and going to have any more, so you might have some idea, but children's needs change all the time. So what's good for a 5-year-old isn't necessarily good for a 12-year-old. And so also it won't have any binding effect, because if one of them says, well, actually, what we agreed 5 years ago doesn't make any sense now. They do double the amount of clubs. It costs this much more to fund those clubs. and you're moving 3 miles down the road, so the commute is harder to school for you. There are all sorts of factors that mean. So I do think it's better to leave more open, the terms of kind of child arrangements and things. Okay. One of the key points to a cohabitation agreement is you can include, when is an appropriate moment to sell this property? How does a sale happen? Does it if they separate and one party says, I want to sell, is that enough? Do you agree that that's enough? Because again, that won't be totally legally binding, but it will be very influential to a judge considering it. And the other thing to think about is the other end of the scale. We talked about lots of couples who are young, potentially having children, but if you think about a couple who are perhaps both been married in the past, their children are adults, maybe their partners, their spouses have died or they've divorced, and they're moving in together, in their older age. Yeah. You need to think about, if one of you dies, can that party's estate force a sale of the property? Yeah. And you can protect against that to make sure, the children aren't forcing the other elderly half of the couple to have to sell their property. What if money is needed for care home costs? How does that work? Yeah. So it's there are all sorts of things that these documents can cover. And as I said before, if you have a declaration of trust, declaration as to interest in the property, that will be legally binding. Yeah. So those are the two documents you're saying, the cohabitation agreement and the interest of the what of trust? What is the name? Declaration of trust. So those would be the two main documents that you want to draft at that stage. Yeah, and I should probably mention one more actually, which is a declaration of trust, but we call it a declaration of no interest. Okay. So that could be if a party owns a property by themselves and a new partner's moving in, and they've got no intention of paying towards the property. Okay. They are just living there because it cuts costs. Why not? And it's a declaration that whatever they do, they will never get an interest in the property. Oh, that's another way. So that's a way of protecting your assets. Yeah. But also making it very clear that there's no intention that they're ever going to pay for anything. Yes. And then everyone knows where they stand. Yeah. It's a neat way of dealing with it. I think the great thing around all these agreements is that they provide that clarity, so people don't enter into this relationship and into this situation without knowing what they're going to end up with if it doesn't work out. Absolutely. I think those are all really helpful tips. Thank you so much, Oscar. I will share your contact details in the description for the podcast. So if anybody has any more questions or wants to discuss their specific situation with you, they can reach out to you and get all of that advice firsthand and tailored to their case. Absolutely. I'd be very, very happy to speak to anyone. Well, thank you so much, Oscar. You have a wonderful day. Thank you, Chloe. Take care.